right. I hope you're doing well. My name is Ali Talai. I'm a trust and estate planning attorney. And today in this webinar, I wanted to talk to you about how an LLC could be something that your plan is missing. As I mentioned, I'm a trust and estate planning attorney. My office is here in Woodland Hills, California. All we do is estate planning. I have a advanced degree in tax law. It allows us to do much better estate tax planning, asset protection planning, trust administration, and those sort of things. And if you're watching this video on YouTube, please do me a favor, give me a thumbs up. Please subscribe to our YouTube channel. We are on other social media, other platforms. Please follow us on those platforms. And having said that, I don't want to take too much time going through those things, and I want to talk to you more about how we could incorporate an LLC, a limited liability company, into your estate plan, and why something like that could be useful to protect who and what you care about the most. All right, so before we sort of get into the planning aspect of it, let's talk a little bit about what is a limited liability company, an LLC. It's really a business structure. It's very similar to the corporations and the partnership and general partnership and limited partnerships. Those are formats that have been around for very, very long time. LLCs are relatively new. They're about, I think, 50 years old. Wyoming was the first state in the United States that enacted LLC statutes. And now every state has LLC statutes. California has them as well. We practice here in California. We use a lot of California LLCs. We use a lot of Wyoming LLCs. There's a reason why we do those things, and we'll talk about that at some point. These LLC, they can be owned by the member, or it can be owned by multiple members. So shareholders are in a context of a corporation. When we talk about an LLC, now we're in this membership interest. Management of an LLC, you don't have to have this, president, vice president, secretary. It doesn't need to have officers. It could have officers. A lot of times we do end up setting up LLCs that have officers within them. But in most cases, these LLC are managed by a manager. And that manager can be someone that is not a member of the LLC, or it could be that it is actually one of the members. When we select these LLCs, there's an option, especially in California, that asks, is the LLC going to be managed by its managers, or managed by its members, or is it going to be a manager managed LLC? And so if it's a member managed LLC, that means its members will do the management, will have that responsibility. And obviously, if it says a manager managed LLC, that means it has a manager. In both cases, the person managing the LLC could be the actual owner, the actual member, or the members of the LLC. However, when you have a manager managed LLC, you have the flexibility of just bringing in somebody that is completely has no relationship, has no ownership within the LLC, and have them be the manager of the LLC for ease of just taking care of things if you don't want to be involved as much. The other thing is, if you have a member managed LLC, a lot of times we help families set up these sort of structures, and they at some point think that they want to give their children a small percentage, maybe 1 or 2%. And I tell them, if you're still looking to keep control, we want to get away from a member managed LLC, because even if a child has a 2%, 3% interest in a LLC, and if it's a member managed LLC, it means whatever you want to do, you're going to get there okay. So that becomes important depending on what we want to do. We could create these LLCs in such a way that it has a voting and non-voting membership interest. So that could, again, provide more flexibility. We do that for management issues. We do that for discounting, valuation, for estate tax planning, lots of different things, that different reasons that these LLCs are used. Let's talk about how an LLC actually works. You create the LLC, you create the entity. There's an articles of organization that gets filed with the Secretary of State. That by filing that by itself, it does not really mean you have an LLC. It just means you have registered the name that you are thinking for this LLC with the Secretary of State. It really needs to have more of an operating agreement. It needs to have other minutes and resolution and other things to really effectuate the ownership. We want to make sure that members have a certificate of ownership that shows their ownership within the LLC. Who could be the member? You could be the member. Your trust could be the member. Your spouse could be the member. There's no restriction as far as who could be the member. Sometimes when we're in the corporation platform and we're talking about, is this an S corporation or a C corporation, there are restrictions as far as who could be the member. You could always add members to it. You could sell a membership interest of the LLC, and it operates as a separate entity in most cases. It has the attribute that it could be taxed as a disregarded entity. That means for federal purposes, you do not need to file a separate tax return for it. At the time the person passes away. So the entity itself, depending how the operating agreement is written, but in most cases, the entity itself could be alive forever, as long as it's operating, as long as it's got asset, it could operate. And the fact that a member of the LLC passes away, it doesn't mean the LLC has passed away. So when we talk about in the context of estate planning, the LLC doesn't die. So if I transfer my property in there, the LLC is still alive, but my membership interest, my share of the LLC, since I have passed away, that does not automatically pass along to anybody else. So a lot of times we want to make sure we have some additional planning for our LLC. We have a revocable trust or some sort of a trust that we've attached the membership interest of our LLC in there. LLC could own realistically anything. I mean, it could own a business. It could operate as a business. It could own real estate. Real estate is really a business. You could be in the business of doing rental, short-term rental like Airbnb. You could do regular leases and other things that you're able to do with real estate, investment accounts. You could own expensive or risky property like airplanes, boats, those sort of things. A lot of times are placed in these LLCs. Benefit of using an LLC. One of the first thing that is comes to mind when we're talking about LLCs and why we're using these things is the asset protection it provides. With LLCs, with limited liability companies, also with partnerships, but since we're talking about limited liability company, you get an outside protection and an inside liability protection. And what do I mean by that? By an inside liability, it means that if a creditor of the LLC sues the LLC and you are a member of this LLC, the LLC provides protection to its members, saying that the assets of the member himself or herself are not exposed to the credit to the lawsuit. That means if I sue the LLC, I could maybe take the asset of the LLC or get this thing called a charging order, but I'm not able to take personal property that belong to a member. That's what I mean by an inside liability protection, meaning that creditors from inside the entity are not going to have access to members' asset outside of the LLC. This inside liability, you get the same thing in a corporation. What a corporation doesn't have is really this outside liability protection, which an LLC, a partnership, provides, is that if now I'm the member, I get in a car accident, somebody sues me, the fact that I am the member of this LLC will not give my creditor any right to be able to take the asset of the LLC. They cannot reach into the LLC and take the real estate that it owns, the bank account that it owns. It does not allow for that. cannot take my membership interest of the LLC. They cannot do that either. You compare that to a corporation. If somebody sues me and I own X amount of shares of a particular corporation, they can attach my shares. They could take my shares from me. Within an LLC, that is not the initial remedy that is available, even in a state like California. In most cases, a creditor could obtain a charging order. And what a charging order does, what it gives the creditor, it doesn't mean they can put, let's say I own a real estate under this LLC and I have $1 million lien against me. It doesn't mean when they get the judgment, their judgment, that they could place the lien on the actual property. The reason is I, a member of the LLC, I don't own the property. I own the membership interest of that LLC. So that's why they cannot put a lien on the actual property that is owned by the LLC. What a charging order allows and provides a creditor is that this building that I have in this LLC, at the end of the year, let's say my allocation of the profit and share, my share is $50,000. At any time when the LLC distributes money to me, that charging order allows the creditor to sort of stay in between the LLC and myself and attach and take the distribution that is made from the LLC. And that's really where you get a lot of asset protection, because you're automatically putting the creditor on a payment plan. They don't have to agree to this practically. They're being put on a payment plan. California, and there are a few other states that have a foreclosure option, which if a creditor could show the distribution is not going to be sufficient to pay back the amount of the creditor's judgment, then they could take possession of my shares. But again, if the operating agreement is written the right way, we could limit them and have them stay as an assignee and have provisions in there that their share could be bought out for minimal amount. Anyways, so that's a little bit as far as how this asset protection works with LLCs. Some states have single member. They have different rules for a single member LLC. So that's something that we want to keep in mind. And that is something that we consult with our client to make sure that we put together the right entity, the right structure. And we use a lot of Wyoming LLCs, a lot of Wyoming holding LLCs, owning California LLCs. There are reasons for that. And hopefully, whenever you're ready to do your own planning, I'll be more than happy to discuss that with you. If you're finding the content of this video helpful, I ask you to share the video with a friend or family member that is looking to do their estate plan and wants to also incorporate some sort of an LLC structure. If they have rental properties, rental real estate investors, this sort of structure works out really great for them. So please go ahead and share the link. I appreciate that. Probate avoidance, as I talked to you about, LLC accounts are owned by the LLC. So if you transfer a bank account, or if you open up a bank account under the name of the LLC, you transfer a property into the name of the LLC purchases the LLC. The LLC itself doesn't die, but LLCs, they don't really have a mechanism in there that would transfer the membership interest of the LLC to somebody. So if there is not the required or the adequate planning in place, when the actual member passes away, his or her share will be stuck practically there. And in order to transfer that to the next, their heir, it would have to require a probate proceeding in most cases. So again, we do these plannings. This is really a portion of the entire plan. So it doesn't mean that you just do an LLC and that's it. It's really having your revocable living trust, having a more comprehensive estate plan, which will include the LLC and some of the other plannings that might be needed. Let's talk about the operating agreement of the LLC. So I'm talking to you about how an LLC could provide asset protection, but I want you to keep in mind that it's really not having the LLC that gives you the asset protection. It's really the operating agreement within the LLC that gives you the asset protection. The operating agreement really outlines the rules that the LLC has. Who are the members, ownership of the members. If there is some sort of conflict, how do we resolve it? Restriction on the transfers, how something gets passed along to the next member. Can you get the investment you place into the LLC back at any time? There's lots of provisions like this that become extremely important when we're talking about an asset protection. For example, I just mentioned the provision in the LLC agreement that restricts the access of the initial capital contribution into the LLC or any future capital contribution into the LLC, and says you could make it, but you can't take it out unless everybody agrees. And so that becomes extremely important, especially in a lawsuit, because if the operating agreement, and it's not uncommon for me to see these provisions in these LLCs. A lot of times I've seen LLCs that says the operating agreement says that if that the member can take the asset they place into the LLC with no restriction. And that sounds good maybe at first, but then the reality of it is if there's a lawsuit against you, you don't want to have a provision like that, because that's going to make the creditor force you to take your distribution out, take the property out, take whatever money you put into the LLC, take that money out. And then the creditor would have access to it. So this operating agreement becomes really the most important document within the LLC to make sure we are getting the asset protection that we're looking for. As I mentioned, we could always tie in a trust agreement for other needs. You're going to need a trust agreement, a revocable living trust, or other kinds of trust to be able to provide for ways to avoid probate, estate tax planning, different reasons that you have these as trust in place. But by having at least a revocable living trust and having the LLC's membership interest owned by the trust, that allows us a way to avoid any court proceeding, any court involvement as after the person that has owned the LLC's membership interest passes away. And the last thing I want to talk to you about, best practices when using an LLC. You want to maintain formalities. You want to make sure you file the report. California actually does not require an annual report. California requires a statement of information to be filed every 2 years. Keep separate accounts, keep money separate. We don't want to commingle anything, all these asset protection and everything that the LLC has. We want to make sure we maintain the formalities, because if we don't, the creditor is going to try to pierce the LLC's veil and gain access to the assets, saying, yes, you created this LLC and it could have provided you with these particular protections, but since you never maintain any formalities and you did whatever you wanted to do with this LLC, you deposited your own personal assets in there, you use the LLC's bank accounts for your own personal needs, they're going to say that this is really just not effective. The LLC is not effective, and they can gain access to the assets within the LLC. So maintaining formalities become extremely important. I hope you found this video helpful. If you have additional questions, please reach out. Our phone number is on the website, on the slide. And once again, Ali Talai, your attorney for life. Thank you.